The Massachusetts Supreme Court will be hearing oral arguments on a case called Commonwealth versus Lindsay Hallinan, and it deals with the issue of what is the standard a judge should apply when somebody files for a motion for a new trial based on the issues that came up in the Ananias litigation regarding the breath test. So somebody took a breath test between August of 2011 and August of 2019, they're entitled to a new trial. And the issue is, what is the standard a judge should apply? I have a motion right now. It's under advisement. I've had some that have been allowed, but judges are differing on what the legal standard is. I've always argued that these motions should be allowed unless there's overwhelming evidence of intoxication. But some judges have resisted this standard, and they're looking for the Massachusetts Supreme Court to sort of set the standard to determine what guidelines trial judges should apply in ruling on these motions. There really hasn't been a flood of motions in the court. I don't see too many motions. I've made probably 7 or 8 of them myself, and this Lindsay Hallinan case is pending. It's a case where the court probably should allow the motion for new trial. Seems like a very strong case on without a breath test. But there's some legal issues that are going to be addressed by the Massachusetts Supreme Court. And one of them is what happens to the license consequence, to the license. So the RMV is taking the position that the suspension starts over. And in a first offense OUI, this might not have significant consequences. But let's say someone has a third offense OUI. They may have served most of the suspension. Third offense is 8 years. Maybe they've served 4 years of the suspension. Now they get their motion for new trial vacated, and they subsequently lose the case. Do they start all over? Do they lose the credit for those 4 years? And one of the arguments that's going to be made to the Massachusetts Supreme Court is that while a license is not considered part of the criminal process, in other words, double jeopardy doesn't forbid the RMV from imposing license consequences in addition to those for a criminal conviction, because a license is considered civil in nature. It's considered a privilege rather than a right. So it's not considered part of sort of the criminal process and the criminal punishment. But with a license in an OUI case, it's so integral and so crucial to the decision of whether to select a new trial that I think the court will say that the RMV can't impose an additional license loss, because what it would do is it would discourage somebody from litigating a motion for new trial. And these motions for new trial, they arose out of misconduct by the Commonwealth during the Ananias litigation. There was some sort of egregious misconduct that Judge Brennan found in withholding 430 failed breath test calibrations in the litigation. This was a litigation where thousands of dollars were spent. Experts were flown all across the country, and at the end of the day, they didn't have all the documents for a full and fair hearing. So the violation was very significant. So I think that the Massachusetts Supreme Court will say that fundamental fairness and the principle that you can't punish somebody for basically exercising their right to an appeal. So in the context of an appeal, there's a presumption that if someone gets a harsher sentence after appeal, the judge is going to have to make written findings. In other words, we don't want to chill or preclude people from exercising their right to appeal because they're afraid that they'll be retaliated against or receive a higher sentence after a subsequent conviction after a successful appeal. So that same logic would apply here. So I would be surprised if the Massachusetts Supreme Court doesn't issue an order mandating the RMV to give the person credit for any license suspension that was served prior to the motion for new trial. I think the court should set a standard requiring the government show overwhelming evidence of intoxication. This was significant misconduct. It's very hard to determine what somebody would have done had there been no breath test. The breath test, a lot of people put a lot of weight in it, and it's the dominant force behind whether somebody pleads or goes to trial. Now, when I talk to my clients, I try to tell them this is only one type of evidence. We can fight this. I didn't resolve too many cases during the Ananias period. I was putting almost all my cases in this litigation unless the case was, in my opinion, not winnable even without a breath test. So I think the standard should be very high. It should require overwhelming evidence of intoxication. And I think the Supreme Court will probably adopt that standard and require the RMV to give people credit for any license loss suspension. Do you have any questions on this? Or if you have questions about the Massachusetts Supreme Court in the Hallinan case, feel free to contact me, 781-686-5924. My name is Mike DelSignore, specialize in OUI cases, follow all Massachusetts Supreme Court cases involving OUI, and it's my passion to help people charged with drunk driving cases in Massachusetts.